welcome to this important webinar organized by SHOAA for Human Rights about the situation of human rights situation in Algeria today. So this webinar will last approximately 90 minutes, where we aim to explore Algeria's alarming decline in fundamental freedoms, including freedom of expression, association, and fair trial, while centering Algerian and international perspectives on how to respond. We are honored to be joined today by distinguished guests from leading human rights organizations who will share their insights on shrinking civic space, digital repression, judicial harassment, among other topics, such as the role of international mechanisms such as UN mechanisms. So thank you all for being here today, and I want to remind everyone that there is instant translation to French and Arabic. So please choose your preferred language to hear this webinar, and I think we're good to go, and I'm gonna start by introducing our guests before we move into the discussion. So we are joined today by Sarah Zidi, who is the Advocacy and Communication Officer at MENA, who will be outlining overall state of civic space in Algeria, examining the systemic restrictions and reprisals targeting human rights defenders and activists. Then we have Mr. Kamal Sidara, Managing Director at EduCyber, who will tackle the topic of digital civic space. Also, we have Alexis Thiry from MENA Rights Group, who is the legal advisor for MENA Rights Group, who will be presenting today the findings of MENA Rights Group's recent report on travel bans. Then we have Debra Long from the Law Society, who is International Policy Manager, she will be addressing the targeting of lawyers and broader implication of this on fair trials and access to justice. We are always also honored to be joined by Mr. Carlos Nagore from the Office of the UN Special Rapporteur on Freedom of Expression, and Ms. Loana Benjamin from the Office of the UN Special Rapporteurs on Human Rights and Counter-Terrorism. So I think we are good to go. So we'll start with Sarah Zidi from MENA. Sarah, you have the floor.
Thank you so much. Welcome, everyone. I'm so pleased to be here. It's such an honor to be sharing the floor with outstanding activists and human rights defenders. I would like to start by giving the general, let's say, context when it comes to the Algerian civic space, since MENA main focus is civic space. So what we have been noticing is a profound and an accelerating erosion of civic freedoms since the emergence of the Hirak movement of 2019. We have been noticing that there is a huge systematic crackdown on. Can you hear me?
Yes, we can hear you, Sarah. Yes, go ahead.
Okay, so what we have been noticing is a systematic crackdown and restrictions on the Algerian civic space. So during the election period, for example, authorities arrested several dozen individuals only because they have been expressing their opinions peacefully. One of the prominent examples was Mohammed Al-Jazid, who faced ongoing harassment since 2019, and he was arrested later on in January 2025 on charges of apology of terrorism, and later on he was released on October 31 by a presidential decree. In a separate case, the Alger court also sentences him for like 6 months in prison just because he has been publishing on Facebook for publications likely to harm the national interest. The authorities have increasingly relied on conspiracy theories and narratives to justify the oppression both inside and outside of Algeria. A discourse that frames human rights defenders, journalists, lawyers, activists as foreign-baked, plot against the state, which is a very common tactic among all of the authoritarian regime. But my main focus today is going to be the legal and financial strangulation of association and how the Algerian regime wants the Algerian civic space to depend on the Algerian government. So the government is ensuring that no movement. Can you hear me? Hello?
Yes. Yes.
Okay, good. Okay. So the government is ensuring that no independent group can form or fund itself or operate without direct state oversight. Um, the Algerian authorities dissolved two prominent groups, Rassemblement Action Jeunesse and Algerian League for the Defense of Human Rights. We also noticed, how can I say that? The legal framework has been increasingly tightened. The Algerian regime has already an existing 2012 law that's has already, I'm sorry, imposed burdensome registration procedures, but a proposed draft under consideration. There is actually a proposed draft under consideration that came up with various restrictions, which are very ironic. The first and the most important one of them is the fact that all of the association cannot form without prior government permission, and the members should be all Algerian citizens, and these Algerian citizens should not be convicted of a criminal offense, which is very ironic because most of the human rights defenders in Algeria have been, as a matter of fact, sentenced. Also, this proposed draft bill forbids organizations from maintaining any relationship with political parties or receiving any financial assistance from them. Of course, alongside the foreign funding, which is subjected to explicit authorization by the Interior Ministry or a governor. Also, MENA and also SHOAA for human rights have been working a lot on travel bans and transnational repression. The Cairo Institute for Human Rights has documented multiple forms of transnational repression. The Algerian regime has been running toward diplomatic pressure on foreign governments when it comes to detention or extradition of activists who are living on the diaspora. Also, harassment of families, doxing and phishing and hacking the accounts, and even further coordination with neighboring countries, reinforcing a regional environment hostile to civic activism. The travel bans, of course, without the subject receiving formal notice or a legal basis, they are very arbitrary and they are often impossible to be challenged in court. The authorities are constantly banning public gatherings. For example, SOS Disparu, which represents families of those who disappeared in the 1990s, was prevented from carrying two events in Algeria in February and March 2025. The state has aggressively weaponized terrorism charges and legislation. The authorities broadened the definition of terrorism with a very broad and open interpretation in June 2021, established a list of terrorist entities and individuals. And in this list, we can find human rights defenders, journalists, lawyers, etc. And of course, the Algerian regime is using terrorism charges in every human rights defender case. The penal code also has been tightened in May 6th. Publications likely to harm the national interest or any kind of information is now seen as an information considered to be sensitive and related to national security, etc. So what we can conclude is the fact that the Algerian regime, the Algerian government, has been architecturizing how can I say that, a very hostile atmosphere for the Algerian civic space. Anyone who criticizes or who challenges the authorities might find himself or herself or whatever charged with very heavy charges such as terrorism. And this creation of an environment that depends solely on the government The Algerian authorities have been, since the Hirak, as I said, undergoing this immense and this tremendous and horrific crackdown on the Algerian civic society. Thank you so much.
Thank you, Sarah, for this comprehensive overview of the situation of human rights defenders and activists and the usual challenges and charges they use and against them, and the troubles also and challenges faced by NGOs in Algeria today. So next we'll move to Mr. Kamal Sedra, who is Managing Director at EduCyber and a savant about digital civic space, who will address the main challenges relating to civic activism and the usual challenges faced by human rights defenders and activists while doing their advocacy and work, human rights work on internet. So Kamal, the floor is yours.
Thank you, Imène. My name is Kamal Sedra, and I'm originally from Egypt. I'm Managing Director of EduCyber. It's a cybersecurity consultancy firm in Switzerland. And I have working for this field since 2009 and work for human rights since 2003. And I used to live in Egypt and do my activism in Egypt and outside. And I understand and I feel the same like most of human rights activists that SHOAA work with. I'm happy also to say I work with SHOAA for now maybe more than a year, and I have the opportunity to meet with a lot of Algerian human rights defenders and organizations, and we did like a need assessment for their online problems on the online infrastructure to know where they are and what they need, and to try to help SHOAA to fill the gap between what in the situation and what they have as digital skills. Algeria is not different than the whole region, which is most of the government is shrinking the civic space, and now because most of the digital activities, it's online, and most of the mobilization using online, most of the advocacy we're using online tools, such social media, Facebook, and other tools. Of course, it's very easy for any government or any organization want to shrink this space is to use the digital tools. As I always said, and I always say in my trainings that like maybe 30 years ago or 20 years ago, if I want to know something about an organization, I'll try to embed like a small microphone or a camera inside their office to listen to what they say, to see what they do, and then I can prepare myself as a government to minimize their impact. But now we all have mobile phones, we all have computers, we communicate online. That's easier for the government or any organization is to try to hack or to make a surveillance to these tools and know what happens. I'm not taking a lot of time, but I tried after our work with SHOAA in Algeria, I try to put some points on what is the digital challenges or cybersecurity challenges for human rights work in Algeria. First, government surveillance, which are using sometimes military grade tools, which is provided by other government or other countries. Some of them are easy to protect yourself as a human rights defender, and some other is not. And they being a lot like Pegasus, Israeli software, which is there is a lot of reports during the past, I think, few years about attacking human rights defenders and journalists and political activists by this tool and other look-like tools, which is a little bit expensive. It's not easy to detect, and also it is very painful for human rights defenders or any activist. other tool like the social engineering and targeted attack, which the government, they have a lot of information about their citizens, and they can use this information, maybe family relation, maybe any other information, to try to did a very, very successful attack, because they rely on a real data. Like they know your birthday, and there is a lot of people put password with their birthdays, or their children birthdays, or lovers birthdays. Because the government know all of this, they can did a scenario, or design a social engineering or attack using this data, and also the data they bring from the surveillance or the softwares. Third is the weak account security. Algeria not a part of normal people in all over the world. Even I did the same work in the United States and in Europe and many countries. We all as people, we all knew in using digital technology. Every day there is a tool, there is something. Not all of us are aware how to secure our accounts. Even if you secure your account, you should regularly look at your check your security settings, maybe every month or every few weeks, because like Facebook, which is a main tool using for activism in Algeria, it's like every 2 months or 1 month you will find difference in the settings. You should go inside and check. Also, one of the main problem is the mobile device targeting, which is not all the people can afford to pay for expensive mobile phones, and even to not all the people they have this awareness to upgrade or to update the software. And these mobile phones is very, very, very useful in attacks from government or any other or bad actors, I want to say. Also, the low awareness of security tools at large. There is a lot of security tools. Some of them are free of charge, some of them open source, and some of them is with maybe you can pay a little to get it. Not also, and also if I'm organization and I have a project, I have funding from funding organization, but most of the organizations, they don't put like a specific budget for cybersecurity because they lack of awareness or lack of knowledge. There is a tools like VPN, like antivirus, like the very, very basic to use the original softwares. As in Middle East, most of the people, not only Middle East, but there is a lot of countries, they use copy softwares. They don't pay for Microsoft Office. They don't pay for Windows. They already downloaded a copy from online and they use it, which is very, very fatal for their security. Also, the service blocking. And during our project with SHOAA, we found a lot of websites is already blocked to be seen in Algeria. Also, the fake news, which is very important, and sometimes fake news against the human rights defender or the organization, and sometimes fake news to let human rights organization write a report about it, and then it fake. It's mean a very big problem for credibility for the citizens from this organization. And I have experience, which I work in election monitoring, and we found through many projects in many countries, we find fake reports came to us as it's a violation. And when we try to verify this information, we didn't find this information. But if we already accept this reports without verification, it's mean the whole report about the real violation is not true, and we miss the main point of credibility. We miss very important thing. It's our real data or our real violation is already a real violations. Also, I have only two more points. Lack of institutional digital security policies. most of the organization or most of the activists work alone, or they work in organizations they don't have a cybersecurity policy. When you open a new NGO in any country, you should have like a bylaws, or you have your system, you have your inside process and procedures. But the problem, most of the organizations, they don't put the same for digital problems. We don't have like a contingency plan online. I mean, we don't have also like incident response policy. We don't have policy at all, or we don't have the awareness that policy is very important for us. We depends on maybe the personal skills and knowledge about cybersecurity, and this put the whole process or the whole project in danger, because if you have someone is very good in cybersecurity and he can secure his accounts and they can send an encrypted message for other colleague or other or anyone work with him, but or she or her. But on the other hand, the other person, they have a fake like Windows. They don't have any awareness about cybersecurity. This means the circle of cybersecurity is broken. Also, the limited access to specialized technical support. In most of non-profit organizations worldwide, not only in Algeria, they don't have a specific person responsible for cybersecurity inside their project or their organizations. Very, very limited organizations, they have this position. And of course, the local organization, which is they have a very, very limited resources for budgeting. They don't have even an IT person. They hire like IT person from outside the organization. And I think I took a lot of time, and maybe at the end I'll wait for any questions. Thanks.
Thank you, Kamal, for this very informative and clear presentation, and for tackling the topic of government surveillance and the misuse of digital tools against human rights defenders and organizations. But also thank you for addressing and talking about some cyber hygiene that could protect organizations and activists while doing their human rights work. Before moving on, I want to remind everyone that there is instant translation to Arabic and English. يوجد ترجمة فورية للغة العربية واللغة الفرنسية. So you can choose which language you prefer to hear. Thank you again. So we now will move to Alexis Thiry, the legal advisor of MENA Rights Group, who will present the findings of recent MENA Rights Group report on travel bans. So Alexis, the floor is yours.
Thank you so much, Imène, and thank you to SHOAA for organizing this discussion. Yes, like you said, I will take some time to maybe present some of the main findings of our report on the use of travel bans in the country, known as ISTN, Interdiction de sortie du territoire national, that we published not so long ago. Just to give you some context about the report, so we've started maybe like around the last UPR of Algeria in 2022, we began hearing testimonies from people being blocked at the borders, sometimes without any explanations, with absolutely no notification when they try to exit the country. So we started to collect these testimonies, and in late 2024, we began working on the matter with Human Rights Watch. We sent a letter with a list of questions to the Ministry of Justice, requesting information, data, clarification on the legal basis. To no avail, we got no response. So we decided to go ahead and publish a joint statement with Human Rights Watch, denouncing the practice, highlighting as well a couple of individual cases. But we wanted to go a little bit deeper and understand the practice and the law, the legal basis as well. We are not the first, obviously not the first to study and cover, analyze the practice. A few articles were published in Algeria media. It was also covered in some recommendations following the visits of 2 UN special rapporteurs who conducted a visit in Algeria in 2023. And based on all the information we gathered, we published the reports in October, so not so long ago. We are also working on a translation of the report into Arabic just to make sure that the findings are shared. The report was published in a specific political context because in August 2025, there was a major reform of the Code of Criminal Procedures with the adoption of law number 2514. This was exactly, like almost exactly 5 years following the adoption of the contested 2020 constitution. There is in this constitution an article on travel bans which guarantees freedom of movement. The restrictions can only apply when there is a reasoned decision and by a judicial authority. And the new Code of Criminal Procedures has a specific, provision on travel bans on ISDN, which can be found at Article 49 of the Code of Criminal Procedures. So when we published the report, we tried to analyze the new provision, but as well as the old provision, which was Article 36 bis 1 of the Code of Criminal Procedures. So we'll share like some analysis of the former provision and of the new one. So under the old Article 36 bis, it was a travel ban could be issued based on a report by the judicial police. There was no judicial oversight except the intervention of the prosecutor, but no judge. There was no notification, no obligation to notify the person, no reasoned decision, and it was based, like I said, on reports of the police. So as an outcome, many individuals, in practice, learned about the travel ban only when they attempted to travel outside the country, at the airport or at the land crossing. And there was as well like no effective remedies, at least codified under the law. Despite the absence of domestic remedies, at least in the Article 36, many individuals actually tried to, send letters to the prosecutor. If there was no response, they tried to approach the prosecutor general. This is something that is called like recours gracieux, but it's in practice, it's very ineffective. They tried as well to, they are trying to contact security forces, sometimes without knowing which security services issued the travel ban. So they tried to contact the DGSN, the Ministry of Interior, the local police station. Some of them also introduced complaints before, like the Council of States, which is the highest administrative body in Algeria. As part of the research we did, we found that most of these attempts, by people subjected to travel bans were ineffective. We only found one decision of the Council of States stating that the travel ban in question was against the law and was also against the ICCPR. But it was the only instance we could find. So like I said, there was a big substantive reform of the Code of Criminal Procedures. So now travel bans on ISDN are codified under Article 49 of the Code of Criminal Procedures. It contains some formal improvements. Some might say cosmetic, but it's important to highlight them. There is now a requirement of a written and reasoned order, but it's still being issued by the prosecutor. There is an obligation to notify the person that is affected by the measure, but there is also now the ability for the person to request the lifting of the ban. So those are the positive improvements regarding contained in Article 49, but there are still some structural problems that we also highlighted. The prosecutor still remains the exclusive authorities in charge of the travel bans. There is no intervention of an independent judge. The duration is still 3 months, renewable once for most offenses. But, and this is, I think, one of the most problematic reform or modifications of the provision. It provides almost indefinite renewals for terrorism, corruption. This was already contained in the previous provision. And this is new attacks on state security. it's a little bit too soon to measure like the effect, of the changes, that are contained. But we will keep monitoring, the to what extent, this little improvement, this cosmetic improvement that I mentioned, how they are applied in practice. Now a little bit like turning to this new ground, for renewal of ESDN, which is state security along terrorism. I just want to maybe take like a few moments to explain why it's problematic. I'm sure like others will also get back to it. This was already covered by the colleague of Hmili, but yes, for terrorism offenses, it can be renewed over and over, like until the closure of the investigation. And we all know that Article 87 bis of the Penal Code contains a very broad definition of terrorism, of terrorist acts. It was criticized by the Human Rights Committee in 2018. It was criticized by the special rapporteurs who conducted a visit in Algeria. It was also criticized as part of a legal analysis, a UN communication sent in December 2021. So this communication tackled these amendments to Article 87, because now Article 87 bis of the Penal Code on terrorism includes, well, like we mentioned before, it creates like a national list of terrorist persons and groups, but it also expands the long list of terrorist acts. So now it includes, acts deemed to threaten state security or national unity, or the functioning of institutions, any efforts to change the political systems through unconstitutional means outside the constitutional means. So this is extremely broad, and this was added to already like a long list of terrorist acts. And we have seen, this is a side note, but the increasing use of accusations of glorification of terrorism. We have seen, the case of Mohamed Tajadid, who was sentenced to 5 years in prison. There is also the case of Ali Mamri, a unionist who was sentenced to 15 years in prison on the basis of Article 87 bis for glorification of terrorism. And the ground of undermining state security is equally broad. And that's one of the grounds, for expanding and renewing the travel bans. So that's, I think, the biggest, fear that we see with the reform. There was, maybe I will not go into too much detail, but before the law modifying the Code of Criminal Procedures was adopted, there was a request for an examination by the Constitutional Court. The Constitutional Court examines the request that was filed by several MPs, and, well, no surprise, but the courts found that the new Article 49 is compatible with the Constitution and the ICCPR, and they validated the reform. In terms of maybe like how travel bans and ESDN, work in practice, it's very hard to measure like the scope of the problem. There is no public data, there is no statistics, no central registry that is accessible, obviously. Many people never receive formal notification. Without notification, lawyers cannot challenge the decision, and it's very hard for them to obtain a copy of the order. We see that a lot of bans or travel bans go beyond the time limits that is provided by the law, so which is 3 months plus 1 renewal for regular cases, and even like outside those cases, even when it has nothing to do with corruption or terrorism, the travel bans are still effective. So it's very hard to estimate the total number of people affected. As part of the report, we documented 30 cases, but it's only like the tip of the iceberg, clearly. Maybe still talking about the practice of travel bans, like who's the most affected. In 2019, clearly there was a spike of travel bans being used, in corruption-related cases. But since 2021, with the rise of the crackdown against, peaceful dissent, human rights defenders, we see that the targeted people, the profiles changed a lot. So we see that political opponents are affected, unionists are also affected, journalists, human rights defenders are also affected, on top of the corruption cases that I mentioned before. But there was really a shift following 2021. And also like how it works in practice. So it can be formal, it can be a formal travel ban when the person receive a formal document, but it can also be a confiscation of travel documents or passports. The passports, when they are confiscated, are not given back. It can also take the form of judicial control, which is not a travel ban, it's not ESTN, but sometimes they are still imposed following the acquittal of the person. The travel bans can be also very informal when the person tries to cross, the border, and they receive like a sentence saying, "Oh, we received some orders from above. We have nothing against you, but you're not allowed to leave the country. You're not allowed to exit." It's not exactly ESTN. It's not exactly travel bans, but it's worth mentioning. We've seen as well journalists and human rights defenders who have been prevented, they hold like the Algerian citizenship, but they have been prevented from entering the country. So I'm thinking of Nacera Dutour from the Collectif des Familles de Disparus, but there was also a journalist from Jeune Afrique who was also denied entry, and they are both Algerian citizens. It has profound impact on the lives, as you can imagine, professional. Obviously, sometimes they are trying to exit the country and they're trying to leave to attend a conference. Sometimes it's for professional reasons. They would like to attend a training or a UN session. I mentioned the UPR before, or sometimes they have meetings, but it can also be personal, when they want to visit family abroad, or they have a medical emergency. And it's the psychological aspect of it also should be highlighted, in the sense that it creates a lot of anxiety due to the lack of information about not knowing when the measure will be lifted as well. And there is obviously like a very symbolic impact as well. It creates a sense of symbolic confinement. It creates as well a chilling effect and a climate of self-censorship. It goes against, I also want to take a few minutes, if I still have some time, to maybe address some of the standards related to freedom of movement, which is contained in Article 12 of the ICCPR. So it protects the right to leave any country, including your own. It's not an absolute right. It can be restricted if it's provided by law, if it's necessary for national security, public order, public health, or morals, if it's proportionate as well, and if it's compatible with other rights. There is a general comment of the Human Rights Committee that provides some guidance about how this provision or this article of the ICCPR should be implemented. It must be exceptional, it must be clearly defined, it might be subject to effective judicial review, and it should not impair like the essence of the right. It's also contained in the African Charter, in the Arab Charter, in the Universal Declaration of Human Rights at Article 13. There is, so the standards are very clear. And when you compare the standards and the law, the legal basis, to Article 49 and Article 36, former Article 36, we see that there is a gap between the international standards and the practice of ESTN in Algeria. There is no case law at the moment of the Human Rights Committee when it comes to travel bans in Algeria, at least not now. But without saying that, like if you look at the law and the practice, clearly, like, yes, there is a legal basis, but the grounds are too vague. Like, I discussed it before, especially when it comes to terrorism and state security. It goes far beyond the restrictions that are provided by the ICCPR. The renewals as well are not proportionate because it's obviously very, very, it's not time limited. There is no notification or review process clearly that is effective. So all in all, we can say fairly that the practice of ESTN really goes against the international obligations of Algeria. They are not the travel bans, just to conclude very, very briefly. They are not neutral administrative tools. They have become a powerful instrument of repression. They violate the constitution of Algeria, the international standards that are, the international obligations of Algeria that I mentioned before, the ICCPR, but also the African Charter. They function like a tool of isolation, of intimidation, and they also shrink the civic space without resorting to imprisonment. In effect, it creates an internal confinement, often targeting people whose only offense is the exercise of their fundamental human rights. And thank you so much for allowing me to present the findings of the report and share some of the concerns about the new provisions and especially the practice of travel bans in Algeria. Thank you so much.
Thank you, Alexis, for this very rich presentation about the travel bans, but also talking about the study done by MENA Rights Group and Human Rights Watch, but also the continued work that you do on this topic. And I know this is something that is not just limited to a report, but it's continuous work towards documenting and monitoring the situation, hopefully doing some advocacy. Yes, the lack of responsiveness by the authorities when we send them communications, and the lack of procedural clarity and lack of information when it comes to these practices done by the authorities. But also, I found it very, very interesting that you commented on the psychological aspects of these practices, because that is very important for human rights defenders, journalists, activists, because it does not just affect them professionally, but also personally on a psychological level. Thank you so much for this intervention and presentation. So now we'll move to Debra Long from the Law Society of England, who is the International Policy Manager. Debra will be addressing the targeting of lawyers and the broader implication of this on fair trials and access to justice. Debra, you have the floor.
Thank you, and I'd like to thank SHOAA for the opportunity to be part of this very important discussion today. The Law Society of England and Wales, we are the independent professional body for approximately 200,000 solicitors, and we are run by and for our members to promote the value of the profession, defend the justice system, and support lawyers in their work. Now, through this, we recognise that around the world, lawyers play a very vital role in upholding the rule of law. They protect access to justice, they challenge abuses of power, defend individual rights, and safeguard the independence of the profession itself. Yet, precisely because of this role, lawyers often face harassment, intimidation, or interference simply for doing their job. In solidarity with colleagues worldwide, the Law Society runs the Lawyers at Risk programme. Now, under this initiative, we advocate on behalf of lawyers who face human rights violations because of their work, and we aim to protect the independence of the legal profession globally. There are many different ways in which we intervene. So we send letters of support and concern. We issue public statements. We also are active both in terms of conducting advocacy before the UN and regional human rights bodies, as well as sending information where there are treaty body considerations of countries. And we sometimes take part in trial observations and fact-finding missions. They're just a few of the advocacy efforts we take. Now, through this work, we are gravely concerned by the escalating harassment and threats faced by lawyers in Algeria. We've seen that these are not isolated incidents. They represent a dramatic attack on the foundations of justice and law in the country. We have already heard since 2019, following the peaceful Harak movement, Algerian lawyers have played a critical role in defending those arbitrarily arrested and prosecuted. In response to mass detentions, lawyers formed the Collective for the Defence of Harak Detainees, aimed at safeguarding human rights and ensuring fair trials. Now, at its peak, the collective had approximately 200 lawyers working to defend individuals whose fundamental rights have been violated. These lawyers provided very essential legal support to those caught up in the crackdown. They raised awareness on unfair trials and politically motivated prosecutions. They worked openly, peacefully, and in line with their professional obligations. But because of this work, these lawyers have themselves become targets. Lawyers of the collective have faced constant monitoring and intimidation, restrictions on access to clients, public vilification, disciplinary sanctions, suspension from work, travel bans, arbitrary arrest, criminal prosecution, and imprisonment. For example, last year we joined SHOAA and other organisations in expressing concern regarding the arbitrary travel restrictions imposed on lawyer Murat Zenati, who was prevented from leaving the country in August 2024 due to a travel ban issued in December 2022. Mr. Zenati was not informed of the court order and remained unaware of the restriction until he attempted to travel. As Alexis has just mentioned in his presentation, this lack of notification of the existence of a travel ban makes it impossible to challenge. As a member of the collective, Mr. Zenati has also faced harassment for several years prior to this incident. In another instance, veteran lawyer Mohammed Shahid, known for his work defending detainees, including those arrested in connection with the Hirak movement, was arrested and detained in October 23 after his home was searched. He is facing a range of very serious charges, including forming an organisation with intent to engage in activities falling under the broad definition of terrorism, as we've heard under the Penal Code, undermining national unity, publishing materials said to threaten public security, and exploiting national tragedy to undermine state security. Now, these charges are all linked to his work and endorsement of a statement calling for dialogue and the release of political prisoners. Similarly, in May 2022, lawyers Abdel Kahora and Yassine Khalifi were imprisoned after calling for an investigation into the death of a detainee and for the release of individuals jailed for exercising their freedom of expression. They received suspended sentences and fines, but were unable to resume their legal practice due to ongoing restrictions and legal challenges. Now, those are just a few examples that highlight a very troubling pattern of intimidation, harassment, and threats against lawyers, using mechanisms such as criminal laws, anti-terrorism provisions, travel bans, and professional disciplinary bodies to interfere with the independence of the legal profession. The harassment of lawyers has also been intensified through legal measures that criminalise legitimate advocacy. Presidential and executive decrees have created a framework that undermines the independence of the legal profession and violates international standards. 3 legal instruments adopted in 2021 are particularly concerning due to their vague and overbroad wording. The Presidential Decree number 2109 imposes up to 15 years imprisonment for sharing secret information, but secret is not clearly defined. The decree can be used against anyone discussing ongoing investigations or legal processes, including lawyers, reporting rights violations to international bodies. We've also heard about the very broad definition of terrorism and its vague terms, which undermine legal certainty and allows authorities to label activists, opposition voices, and lawyers as terrorists for actions protected by rights to expression, assembly, and association. Finally, we have also heard about the process for adding individuals and organisations to terrorist lists without judicial oversight, and the imposition of measures such as freedom of movement restrictions, travel bans, asset freezes, and limits on professional activity. As a party to key international treaties, including the International Covenant on Civil and Political Rights, Algeria has an obligation to respect, among others, the rights to liberty, a fair trial, freedom of expression, freedom of association, and also to ensure the independence of the judiciary. Yet current practices stand in very stark contrast to these commitments. In addition, the United Nations Basic Principles on the Role of Lawyers and now the new Council of Europe Convention for the Protection of the Profession of Lawyer specifically recognise that lawyers must be able to perform their duties without intimidation, hindrance, harassment, or improper interference. They also recognise that lawyers' right to freedom of expression and association must be respected. The current situation in Algeria reflects profound breaches of these internationally recognised principles. Now, the implications are profound. When lawyers cannot carry out their work, it affects everyone. Individuals lose access to legal defence, abuses go unchallenged, and authoritarian practices gain ground. Therefore, lawyers must be able to carry out their professional duties without fear of reprisals. They must be able to speak out in defence of the rule of law and human rights. Yet in Algeria and across the globe, we've seen a troubling pattern of lawyers being targeted when exercising their right to freedom of expression. Now, in January, we will be pushing a thematic report when lawyers are silenced, how restrictions on expression, human rights, justice, and democracy. In this report, we identify three main categories of laws being used against lawyers across the globe to prevent them from exercising their right to freedom of expression. Now, first, there are laws designed to restrict freedom of expression, perhaps legitimately, but applied arbitrarily, such as laws on sedition, criminal libel, or insulting language. Second, there are counter-terrorism or national security laws, which are often include overbroad and vague offences and carry very severe penalties, and also attract restrictions on fair trial guarantees. Lastly, are the group of laws, regulations, and codes of conduct that govern the legal profession, where disciplinary measures and disbarment are misused as tools of control. Now, in Algeria, we have observed these types of laws and measures being applied to science lawyers and prevent them from doing their job. For lawyers, the right to freedom of expression is particularly critical. It's the basis on which lawyers conduct themselves in court, advocate for legal reform and human rights, and speak out against injustice and educate the public on legal issues. Therefore, the targeting of lawyers in Algeria is not simply a professional concern, it is a societal one. When lawyers are intimidated into silence, we've seen that arbitrary arrests increase, torture and other ill treatment go unchallenged, fair trial standards are ignored, and public confidence in the judicial system is eroded. Therefore, lawyers do not ask for special treatment, they ask only for the conditions that allow them to serve the public, to do their job, to defend access to justice, and challenge abuses of power. Therefore, accordingly, in conclusion, the Law Society joins others in urging the Algerian authorities to immediately and unconditionally release those lawyers who've been arbitrarily detained, immediately halt all interference with lawyers, and ensure that they can practice without fear of reprisal. And lastly, to review and amend problematic legal instruments to ensure that they cannot be misused to silence legal advocacy and expression. Thank you for listening.
Thank you, Debra, for this comprehensive explanation and for addressing the role of lawyers and the harassment threats they face. Let's not forget that lawyers are in the front line of this fight against human rights violations, such as activists and human rights defenders. So protecting this profession and these individuals is very important. But also thank you, and Alexis, also for talking about the misuse of terrorism laws, such as Article 87b, that is being frequently and more used to silence activism and human rights work. So thank you again for this presentation. And now we'll move to Carlos Nagore from the mandate of the UN Special Rapporteur of on freedom of expression. Carlos will be raising awareness about the mandate, how it works, how it can help individuals, and how to contact them. Carlos, the floor is yours. Thank you.
Thank you very much, Imène. Assalamu alaikum, bonjour à tous et à toutes. I'm very happy to be here with in this panel with our fellow panelists and with all of you, great civil society, human rights defenders and colleagues. As Imène said, I support the mandate of the Special Rapporteur on freedom of opinion and expression here from OHCHR in Geneva. And it will be a bit of a different intervention from our case, as we are not allowed to comment on the human rights violations occurring in the countries, but actually the purpose of our intervention at the end of this panel is to draw attention to the mechanisms of the Special Rapporteurs, in this case on freedom of opinion and expression, what they are, how civil society and the mechanisms can engage, and how can they be and their work be of usefulness for your work as civil society, as human rights defenders, and others working on Algeria in particular. So first of all, of course, we have to start, for those that are not familiar with what are special procedures. They are independent experts, independent from the UN, but appointed by the Human Rights Council. So this allows them to work under the umbrella of the UN, but with independence that characterizes this mechanism. It is important to highlight that in contrast to other human rights mechanisms, it is not necessary to exhaust domestic remedies to access the special procedures mechanisms. Anyone through the publicly available emails in the web pages of its Special Rapporteur's webpage, or through the platforms for submissions, I will share the links later in the chat, can convey any kind of information to the Special Rapporteurs to bring their attention on a certain case, to highlight human rights violations directly. And so in this case, it is a very accessible mechanism to civil society, to human rights defenders, and to victims themselves. No need for representation of lawyers or others. And in this regard, we are in close touch with many organizations represented here today. So in particular, regarding the mandate of the Special Rapporteur on freedom of opinion and expression, of course, journalists are our constituency in a way, and media freedom, freedom of the press, and the safety of journalists are at the very core of our mandate. But the mandate extends way beyond that to, of course, cover as well any violation of freedom of expression that can happen in the physical sphere or in the online sphere. Certainly, in any cases of reprisals for any citizen that may have exercised the right to freedom of expression, commenting on the situation in their own countries, and face any kind of punishment that is disproportionate, that doesn't meet international standards. We also cover, of course, civic space and the state of civic space in countries across the world. And of course, just to mention a couple of the priorities that the mandate has had in the last years were, of course, disinformation and disinformation in conflicts, disinformation with a gendered angle. Of course, the issue of safety of journalists that I mentioned, journalists in exile and transnational repression is also an area of concern for the mandate. And the gender angle of regarding freedom of expression has also been a big concern for our mandate holder, Ms. Erin Khan, whose mandate is concluding this next 31st of July. But we will have another mandate holder, of course. So the mandate keeps working. So this is a brief introduction of the mandate. More can be found, of course, in our webpage. And I would like to explain, of course, what the mandate can do, and then refer to the work that the mandate has already conducted in relation to Algeria. The main work, the method of work for the mandate is, of course, the communications. These are letters that are sent to the government that include some allegations of facts, normally, obviously, concerning human rights violations, in our case of freedom of expression. Then those facts are followed by the concerns that the experts, normally several experts together, and then we have our colleague from the Counter-Terrorism mandate that will also complement my explanation, but several experts together raise with the government, and then they ask questions to the government on those cases, on those human rights violations, expecting, of course, a response from the government that sometimes provides useful information for the victims, or we see the justification that the government provides to a certain case, and of course, the letters and the responses are then made public and can be used for advocacy. I want to emphasize that there is also a category of communications that is about legislation, what we call other letters, and address the concerns that the experts may have about the compatibility of certain pieces of legislation with the international human rights standards. And in this case, it is important to also highlight the allegation letters that are the most common letters. On specific cases, they are private, they are confidential for 60 days, and then they are published in the website. I will share the link so that everyone can see the work that the mandate and the other special rapporteurs have been doing on Algeria in particular. And in the case of the other letters on legislation, just 2 days after the letter is sent to the government, they are published. So that's, and of course, if there is a response from the government, it is also published and accessible to everyone. What many civil society emphasizes that even if there is no response from the government or it is not convincing or particularly helpful, it is always useful to do advocacy once the letter is public. And I want to share as well that in some occasions when the special rapporteurs consider it appropriate, there is a press release, a public statement that follows a communication on a certain case. That's regarding the communications and public statements. Then, of course, there is the toolbox. In our toolbox, there is the tool of country visits. The country visits are conducted at the request of a special rapporteur, but need the invitation of the country. As previous panelists have mentioned, the special rapporteur on human rights defenders was visiting Algeria a couple of years ago and met with civil society, of course. They produce a report that goes to the Human Rights Council that is public and has recommendations for all. And then the last tool that I wanted to mention, of course, in addition to communications and the country visits, are the thematic reports. These are reports on a particular theme concerning each of the mandates. The mandates publish a call for inputs, welcoming contributions from civil society and everyone on that topic, and then they present the report to the Human Rights Council. So this is, in a nutshell, special procedures, and a very important question or issue to highlight is how to contact them. As I said, I recall there is the email of the mandate that is public in each of the special procedures website, and there is, of course, the platform for submissions that is also a website where the cases, information, any kind of concerns about human rights violations can be shared. We have to note that there is very limited capacity per mandate, unfortunately, approximately 1.5 or 2 staff per mandate with the mandate holder. So that's our constraint. We would like to be able to do so much more, but we have that constraint that there is limited staff and limited capacity. So we need the submissions from civil society and from the victims, and submissions that are as targeted, as specific, as concrete, and strategic as possible, so that they can more easily trigger an action by the experts, of course. And just to mention some recent cases where the Special Rapporteur on Freedom of Expression has been sending letters to the government, and together, of course, with other Special Rapporteurs, in the last couple of years, simply the Special Rapporteur sent concerns on the cases of Jamila Bentui, of Ali Mameri, of Omar Bousak, Sofiane Wali, Tufik Belala, Juba Mangalet, Mustafa Benjama, Taher Larbi, Abdallah Benaoum, Boualem Sansal, and Nasera Dutour also recently. And of course, the mandates continue to work on several cases. Although, as I said, during that time of 60 days, that work is confidential and then made public, so I cannot give more details on the current work, but certainly keeping Algeria very closely on the radar. I know this is true for our mandate on freedom of expression, but also for human rights defenders, counter-terrorism, freedom of assembly, and many others. So this is just to mention the recent work of the mandate. As you may have recognized some of the names, and there are different profiles. Some are human rights defenders, some are journalists, some are even lawyers associated with the law profession. The idea is that if there is a case where freedom of expression has been restricted, the mandate can take it forward, bring it to the attention of the government, and ask questions that reinforce maybe the message or the work that civil society are doing on those cases. So this is the the tool, this is the mechanism of special procedures and how we can be reached and accessed. Of course, the special rapporteur intends to keep a very close eye on Algeria for the remainder of her mandate. The new rapporteur will certainly do it as well, and we really rely and count on the work of civil society, of our colleagues, human rights defenders and victims themselves, to inform us, to bring to our attention the cases they would like to, so that the special rapporteurs can react. And obviously looking forward to any questions and responding to them at the end in a more specific manner. Thank you very much to the organizers and everyone.
Thank you very much, Carlos, for this very informative and clear presentation. I believe many individuals are eager to learn about those mandates and how to contact them, how to reach them, how the mandate works, because we get many questions from activists and human rights defenders and journalists from Algeria, always about how to use special procedures and how to reach you. Thank you so much. We'll see later if someone has a question for you. In the meantime, we'll move to our last guest speaker, Ms. Loana Benjamin, also from the Office of the UN Special Rapporteur on counterterrorism and human rights. As Carlos did, she will be explaining the mandate's work, how to contact them, how to reach them, and what can the mandate do and don't. So, Loana, the floor is yours.
Thank you so much, Imène, and thank you, Carlos, for giving such a good background of special procedures. I'm not going to repeat the procedures because they're also applicable to us. But I want to thank the organizers for having me on behalf of the Special Rapporteur on the promotion and protection of human rights and fundamental freedoms. And thank you for convening us all together to reflect on the human rights situation in Algeria. I will speak a little bit about the main concerns in terms of terrorism that have arisen in Algeria and that the Special Rapporteur has reacted on. So over the past 4 years, the mandate led and joined more than 10 communications on the situation of human rights in Algeria. Particularly, the main concern has been the vague and overbroad framing of Algeria's counterterrorism offenses, the expansion of terrorism-related crimes through 4 legislative amendments, and the corresponding disproportionate sentences, as well, of course, as colleagues have mentioned before me, the misuse of counterterrorism legislation to suppress dissent and civil society in Algeria. So on many occasions, the Special Rapporteur has reiterated that vague and overbroad definitions of terrorism create fertile ground for abuse, arbitrary application, and human rights violations. He has urged Algeria to reform its terrorism definition in line with international standards, including the mandate's model definition of terrorism and Security Council Resolution 1566 on the definition of terrorism. In Algeria, like in a number of other countries, these imprecise definitions have facilitated weaponization of domestic counterterrorism framework against political opponents, minorities, civil society actors, more and more labor unions in recent times, activists, and human rights defenders, among others. And international standards, including Pillar 4 of the UN Global Counterterrorism Strategy, make clear that counterterrorism measures can never be used to target political opposition, civil society, or dissent. As I said, these concerns have been brought to the attention of the government of Algeria on several occasions. In particular, in 2021, the mandate, together with the Special Rapporteur on freedom of expression, special rapporteurs on freedom of assembly and association and on human rights defenders, as well as the working group on arbitrary detention, sent a joint communication to the government of Algeria in which they expressed serious concern regarding Order number 2108, which purported to amend the criminal code and introduce several new terrorism-related offenses. In the letter, the mandate holders emphasized that the definition of terrorism under Article 87 bis doesn't comply with international legal standards, particularly the principles of legality, necessity, proportionality, and non-discrimination, and the requirement under Article 15 of the ICCPR that criminal laws be sufficiently precise to enable individuals to foresee what conduct constitutes an offense. They also expressed concern about the criminalization as terrorism of a number of offenses that are not intended to cause death or serious harm. Relatedly, and a further concern is the inclusion, as Alexis mentioned earlier, of speech-related offenses, such as apology or encouragement, glorification of terrorism, which, beyond being formulated in vague terms, unduly infringe the right to freedom of expression and opinion. And this trend mirrors a global pattern that we're seeing in recent times. We've seen a troubling proliferation of speech-related terrorist offenses, including apologie du terrorisme in various other countries. And these offenses are used to silence dissent rather than address any genuine security threats. These offenses have become a powerful tool to repress criticism and legitimate political expression. And these offenses stand in stark opposition to the Special Rapporteur's model definition on terrorism, which explicitly warns against relying on vague concepts such as glorification or promotion of terrorism. And I just want to come back a little bit on the Special Rapporteur's model definition, in which he says that the offense of incitement or advocacy of terrorism can only be consistent with international human rights law if it meets strict criteria. Namely, it has to be limited to the incitement of conduct that's truly terrorist in nature. The restrictions to freedom of expression must be no more than necessary for the protection of national security, public order, public health, or morals. The restrictions must be prescribed by law in precise language, including by avoiding reference to vague terms such as glorification or promotion of terrorism. And there must be an actual objective risk that the act incited will be committed. And there should be two elements of intent. The first, an intent to communicate a message, but also an intent that the message actually incite the commission of a terrorist act. And finally, the offense should preserve the application of legal defenses or principles leading to the exclusion of criminal liability by referring to unlawful incitement to terrorism. So we see that there are strict restrictions on what kind of offenses would be allowed to be restricted to incitement or advocacy of terrorism. And another concern that has also been mentioned previously is the instrumentalization of terrorist listings and designations against human rights groups, advocates, dissent. And these listings, they might be legitimate when they're targeting individuals or entities directly involved in conduct that meets the precise definition of terrorism, and where procedural safeguards are expected. However, in the case of Algeria's national listing procedure, there's a lot of concerns insofar as it allows for excessively broad grounds for designation and appears to lack sufficient legal safeguards. Listings have a deleterious effect on individuals because they're often accompanied by other measures such as travel bans, asset freezes, restrictions on political and civil participation, the withdrawal or denial of official documents, among other measures. They can also trigger further criminal offenses. And in Algeria, we've seen that authorities have increasingly relied on administrative measures as a means of political repression, in particular travel bans, as Alexis mentioned earlier. And the special rapporteur is particularly worried about the lack of procedural and judicial guarantees because there's less of such guarantees available in relation to administrative measures than in criminal proceedings. Given the global expansion of administrative measures and the significant impact that they have on human rights, the Special Rapporteur dedicated his most recent report to the General Assembly to identifying best practices for protecting human rights when using administrative measures to prevent terrorism and violent extremism. And this report is available on the website of the Special Rapporteur. It focused on 4 very common administrative measures, namely restrictive orders, listings, administrative security detention, and compulsory preventive interventions in relation to preventing violent extremism. And in the report, the Special Rapporteur underscores the misuse of terrorist and extremist designations to suppress human rights. And he highlights the risk of infringement on a wide range of human rights, including freedom of thought, conscience, religion, opinion, expression, assembly, association, political participation, non-discrimination, just to name a few. He also outlined the minimum due process guarantees that need to be required for listings and reminds that even where an individual or entity meets the formal criteria, listings must still be necessary and proportionate in the circumstances, including by demonstrating that less invasive measures such as surveillance or criminal investigation would be ineffective. Any criminal offenses that flow from listings must also be defined precisely, and the prohibited acts must proximately contribute to the commission of terrorist violence. The Special Rapporteur is committed to continuing to raise these issues with the government of Algeria to ensure compliance with its international obligations and to ensure that counterterrorism measures are not misused to unduly restrict the exercise of protected rights and the exercise of legitimate activities. And I'd like to conclude by noting that the next thematic report of the Special Rapporteur will seek to revise and update the mandate's model definition. So the mandate had a model definition in 2006 that was updated in 2010. And now he seeks to update it again to explore the potential need for a definition of terrorist organization and also to examine whether violent extremism is capable of adequate definition and what would be the implication for whether and how this concept should be used. And so in this regard, we issued a call for input earlier this month, and it remains open until 1 December, which is Monday. I'd like to end saying that the Special Rapporteur, of course, remains available to receive concerns that you may wish to submit under the communications procedure that my colleague Carlos explained earlier. The website is a good resource for that. There's the email of the of the mandate on the website. And so please feel free to bring to our attention any concerns that you might have. And of course, I'd like to end acknowledging the essential work that's carried out by civil society to promote human rights and accountability. And thank you all for collaborating with the mandate. Thank you.
Thank you, Loana, for this insightful and rich presentation about the special rapporteur's mandate and tackling very important points, which I think all we can agree on, especially the misuse and weaponization of counter-terrorism legislation and the need for Algeria to meet international standards, especially when it comes to the definition of terrorism and other information you mentioned. Debra, you can go ahead.
Yeah, so I was just reflecting on your question to us, actually, in terms of what could be useful now for support for civil society. And I think, as we've just heard from the previous speaker, actually, just the fact that it's such a challenging environment for civil society in its very broadest term, that actually creating spaces like this and others and those opportunities to share information, to be raising awareness around what's happening, to then be able to engage others, I think is crucial. So I think certainly spaces such as this and others. So trying to create those opportunities and spaces that are safe for those to be able to share their own lived experience is very important, but also to engage with others, such as the international legal community, but also we have representatives from other parts of the international community for us to have a bit more joined up thinking and to speak with one voice, because we are louder that way, I think is very crucial. And so I just kind of call for more opportunities like this, I think, to support civil society and also for us also to take away advocacy with our governments where we are based, in order to ensure that they are also speaking robustly in support of civil society and in the defence of that space, because it's crucial. And so there's just a few thoughts there. Thank you.
Thank you, Debra. Thank you. Yes, I completely agree. Creating safe spaces like this, where we can all share information and insights about the situation, what can be done, what are the safe resources or remedies that Algerians can take. This is very important in order to support them in their human rights work. But also, I believe connecting them and networking Algerian human rights defenders, activists, journalists, lawyers, it is very, very beneficial for them to be connected with their international organizations or individuals. This can help in advocacy, but also in education. This could be very informative and educational for human rights and activists in Algeria to connect with the international society. Of course, sure.
No, I mean, I spoke about travel bans, and I heard like also some testimonies about, passports not being renewed and everything. I think the issue of ESTN and travel bans that we covered in the report, like, yes, the individuals are not detained, but it must be read, not in isolation with all the restrictions, that are affecting the civic space. We talk about hundreds of people behind bars. We talk about the most prominent, human rights NGOs in Algeria that have been dissolved. Independent media also no longer exist in Algeria. Journalists have been prosecuted and sentenced as well. So I think the issue of the restriction on civic space and the travel bans, they're all related, and that's really something I wanted to highlight before closing. But thank you again. That's all for me.
No, thank you, Alexis, for adding this important remark. Anyone else of our speakers wants to add anything? I think Rashid, anyone else? All good? Okay, I think we're good for now. So on behalf of SHOAA for Human Rights, I would like to sincerely thank each and every one of our speakers and participants for joining us today for this very important conversation on the state of human rights in Algeria. Over the past 2 hours, we've had powerful interventions and very insightful contributions and presentations about the deteriorating state of civic space and the increasing use of many practices such as digital repression, the weaponization of counter-terrorism, and the judiciary, and the systemic targeting of even lawyers who are in the front line of this defense against human rights violations. I want to extend my heartfelt thanks to all of our guest speakers, Sarah, Kamal, Alexis, Debra, Carlos, and Loana, and Rashid. And your expertise and commitment to human rights is very inspirational. Thank you all again for joining us today, and looking forward to see you on similar events in the future.